The certified letter arrived on a Tuesday afternoon in October, and I knew before opening it that my life in Pleasant Valley, Arizona, was about to get significantly more complicated. My name is Sean Ortega, and I had been living in the Sunset Ridge HOA community for exactly 14 months when Patricia Henderson, the HOA president, decided I was her personal enemy. The letter inside that envelope was typed on official HOA letterhead, filled with legal jargon and threats that made my blood pressure spike. They were threatening to sue me for $20,000 in damages, legal fees, and something called community disruption costs. The alleged violation. My shed was apparently 6 inches too tall, according to some obscure subsection of the community guidelines that nobody had mentioned, when I built it with full written approval from the Architectural Review Committee, 8 months prior. I stood in my kitchen, reading the letter 3 times to make sure I understood correctly. They wanted me to tear down the shed I had spent 2 weekends building, reimburse them for inspection costs, and pay their attorney fees for a lawsuit they had not even filed yet. The letter gave me 10 days to comply or face legal action. My hands shook as I set the paper down on my granite countertop. I had followed every rule, gotten every signature, submitted every form in triplicate. This was insane. The shed in question was a simple 10 by 12 structure in my backyard, where I kept my tools and lawn equipment. I had submitted detailed plans to the Architectural Review Committee back in February, including exact dimensions, paint colors matching my house, and even the type of shingles I planned to use. 3 members of that committee had signed off on it. I had their approval in writing, dated and everything. Patricia Henderson herself had been one of the signatories. I pulled out my file folder where I kept all my HOA correspondence. There it was, clear as day. The approval form with 3 signatures, including Patricia's loopy cursive at the bottom. The plans clearly stated the shed would be 9 feet tall at the peak. I had measured it myself multiple times during construction. It was exactly 9 feet tall. The community guidelines allowed structures up to 10 feet in height without special permits. My phone rang. It was my neighbor, Marcus Chen, calling from 2 houses down. "Sean, did you get some weird letter from the HOA?" he asked without preamble. "Yeah, just now. About my shed." "This is crazy, man. Patricia is on a warpath. She tried to find me last month because my maple tree drops leaves in the fall. Actual leaves. From a tree. She wanted me to rake them twice a day during peak season or pay $100 per day fine. What did you do?" I told her to pound sand. She backed down when I mentioned calling a lawyer. But you know what I heard? She's pissed because her son's construction company wasn't hired to build your shed. Apparently, she's been steering all HOA members to use her kid's business for any home improvements. That hit me like cold water. I had noticed that the approved contractor list the HOA provided only had 1 construction company on it, Henderson and Sons Building. I had not used them because their quote was nearly double what I ended up paying for materials to do it myself. Patricia's son Derek had actually come by my house when I was building the shed, made some comment about how I should have hired professionals, and left in a huff when I politely declined his unsolicited advice. "So this is revenge," I said. "Probably. Look, I know a good real estate attorney. My cousin used her when his HOA tried to foreclose on him over some trumped-up charges. Her name is Rachel Kim. Want her number?" I did. Marcus texted it to me immediately, and I called Rachel's office before I could talk myself out of it. The paralegal who answered put me through after I explained the urgency. Rachel Kim had a crisp, professional voice that immediately put me at ease. "Mr. Ortega, tell me what happened from the beginning." I explained everything. The shed, the approval, the letter, the threats, Patricia's son's construction business. Rachel listened without interrupting, and I could hear her typing notes. "You have the original approval in writing?" she asked. "Yes, with signatures." "And the plans that were approved clearly show the height. Every dimension is listed, 9 feet tall. The guidelines allow up to 10. Did you build it to the approved specifications?" "Exactly. I can send you photos with a tape measure if needed." Rachel was quiet for a moment. "Mr. Ortega, this sounds like a textbook abuse of process case. They're threatening legal action not because you violated any actual rule, but to harass you or possibly to benefit Patricia's family business. That's illegal. If they file a lawsuit against you, we can counterclaim for abuse of process, malicious prosecution, and potentially other torts depending on what else we uncover. They gave me 10 days to respond to this letter. Don't respond directly to them. Let me send a letter on your behalf. I'll inform them that you have legal representation, that their claims are baseless, and that any frivolous lawsuit will be met with a vigorous defense and counterclaims. That alone might make them back off. And if they don't back off, then we fight, and based on what you're telling me, we win. My retainer is $3,000. If we counterclaim and prevail, you can potentially recover your attorney fees from them." I swallowed hard. $3,000 was a lot of money, but $20,000 plus legal fees and tearing down a perfectly good shed was worse. "Let's do it." We set up a meeting for the next morning at her office in Phoenix. I spent the rest of the evening gathering every document, photo, email, and text message related to the shed and my interactions with the HOA. I had saved everything, including the original architectural review application with all its attachments. Rachel's office was in a modern building downtown with floor-to-ceiling windows overlooking the city. She was younger than I expected, maybe late 30s, with sharp eyes and an air of competence that made me feel like I had made the right choice. We sat in her conference room, and I spread out all my documentation. She went through everything methodically, taking photos with her phone, making notes on a legal pad. When she got to the approval letter with Patricia's signature, she actually smiled. "This is gold," she said. "They approved the exact structure you built. The letter you received claims your shed violates guidelines, but it doesn't cite any specific violation because there isn't one. The height they're claiming is too tall. Where did they get that measurement? I have no idea. Nobody from the HOA has even come to my property with a tape measure. So they're making it up. Mr. Ortega, I think they're bluffing. They won't actually file this lawsuit because they know they'll lose, but let's call that bluff and make sure they understand the consequences." Rachel drafted a response letter that afternoon. She emailed me a copy before sending it. The letter was beautifully crafted, laying out in precise legal language exactly why the HOA's threats were baseless, citing the approved plans, the community guidelines, and several Arizona statutes regarding HOA authority and abuse of process. The final paragraph stated that any lawsuit filed without merit would be met with counterclaims for abuse of process, intentional infliction of emotional distress, and violation of Arizona HOA laws, with requests for damages, attorney fees, and sanctions. "That should get their attention," Rachel said when we spoke on the phone. "I'm sending this certified mail so they can't claim they never received it." 3 days later, Patricia called me directly. I let it go to voicemail. Her message was clipped and angry. "Mr. Ortega, this is Patricia Henderson. I received a very hostile letter from some attorney claiming to represent you. I don't appreciate being threatened. The HOA board stands by our position. Your shed is not in compliance, and if you don't remove it, we will proceed with legal action. You have 7 days remaining. I forwarded the voicemail to Rachel. Perfect, she said. They're doubling down. Save every communication from them. If they sue, this helps prove malice. The 7 days passed slowly. I went to work, came home, tried not to obsess over the situation. I worked as an IT consultant for a medical device company, and it was hard to focus on network security protocols when I was worried about losing $20,000 to a vindictive HOA president. On day 8, nothing happened. Day 9, still nothing. On day 10, I got another certified letter. This one was different. It was a formal complaint filed in Maricopa County Superior Court. Patricia and the Sunset Ridge HOA were suing me for $25,000 now, claiming breach of covenant, violation of community standards, and diminishment of property values. They had actually filed the lawsuit. I called Rachel immediately. "They filed," I said, my voice tight. "Fax me the complaint right now. Actually, scan and email it if you can." I did. 20 minutes later, Rachel called back. She sounded excited. "Sean, this complaint is a disaster. For them, not you. They're claiming your shed violates guidelines, but they don't specify which guidelines. They claim it wasn't approved, but you have written approval. They claim it's too tall, but they don't provide any evidence of its actual height, or explain why their approved plans showed 9 feet if 9 feet isn't allowed." This is exactly the kind of frivolous lawsuit that abuse of process claims are made for. So, what do? We file an answer denying their claims, and we file a counterclaim. I'm going to ask for summary judgment on both their claims and our counterclaims. Summary judgment means we're asking the judge to rule without a trial because the facts are so clear that no reasonable jury could find in their favor. How long does that take? A few months typically. But I'm also going to file a motion for sanctions against their attorney for filing a frivolous lawsuit. That might speed things up. Over the next 2 weeks, Rachel prepared our response. The counterclaim was comprehensive. We sued Patricia Henderson individually, and the HOA for abuse of process, malicious prosecution, breach of the governing documents since they had approved the shed, intentional infliction of emotional distress, and violation of Arizona's HOA statutes. We asked for $50,000 in damages, all attorney fees, and a court order prohibiting the HOA from any further harassment. The abuse of process claim was the cornerstone. Rachel explained it to me during one of our meetings. Abuse of process means using the legal system for an improper purpose. They're not suing you because you actually violated any rules. They're suing you to harass you, to punish you for not using Patricia's son's construction company, and to intimidate you into compliance with demands they have no legal right to make. That's textbook abuse of process. When the counterclaim was filed, things got interesting. I started hearing from other neighbors who had been contacted by Patricia. Apparently, she was going door to door telling people that I was a troublemaker who was suing the HOA and that everyone's dues would have to go up to pay for legal fees. She was painting me as the villain. Marcus called me one evening, laughing. "Dude, Patricia came by today. She told my wife that you're trying to destroy the neighborhood and that we should shun you. My wife told her that you're the nicest neighbor we have and that Patricia should get a hobby." Another neighbor, Deanne Foster, reached out via email. She lived 3 houses down from me. "Sean, I wanted you to know that several of us think what Patricia is doing to you is wrong. She tried the same thing with the Johnsons last year over their fence. They ended up moving rather than fight her. But some of us are tired of her bullying. If you need character witnesses or anything, let me know." That email meant more to me than Deanne probably realized. I had been feeling isolated and anxious, worried that the whole neighborhood thought I was some kind of criminal. Knowing that people saw through Patricia's tactics helped. The HOA's attorney, a guy named Richard Paulson, sent Rachel a settlement offer in December. They would drop the lawsuit if I removed the shed and paid their attorney fees of $8,000 so far. Rachel's response was immediate. Absolutely not. We're going to trial if necessary, but I think we'll get summary judgment first. In January, Rachel filed our motion for summary judgment. The memorandum supporting it was 40 pages long, meticulously citing case law, HOA statutes, and the facts of our case. She argued that their lawsuit was objectively baseless because I had written approval for the shed and had built it exactly to specifications. She argued that no reasonable person could believe their lawsuit had merit, which proved abuse of process and malicious prosecution. We also submitted declarations from me, from Marcus about Patricia's pattern of harassment, and from Diane about the Johnsons being driven out. We submitted the photos of my shed with measurements, the approved plans, the HOA guidelines, and every communication we had received. The HOA filed their opposition in February. It was weak. Their attorney argued that the Architectural Review Committee had made a mistake in approving the shed, that they had the right to correct mistakes, and that the lawsuit was brought in good faith. They provided no evidence that the shed violated any actual rule. They couldn't, because it didn't. Rachel filed a reply brief that took apart their arguments piece by piece. The hearing was scheduled for March 15th. I took the day off work for the hearing. Rachel met me outside the courtroom at the Maricopa County Courthouse. "You don't have to say anything today," she told me. "This is all legal argument, but I want you here so the judge sees that you're a real person affected by this." The judge was the Honorable Margaret Brennan, a woman in her 60s with reading glasses on a chain around her neck. Both attorneys approached the bench, and Judge Brennan looked over her notes. "I've reviewed the moving papers, the opposition, and the reply," she said. "Counselor Kim, this is your motion. I'll hear from you first." Rachel stood. She was calm and confident. "Your Honor, this case is about an HOA that approved my client's shed in writing, then sued him for building it exactly as approved. The abuse of process is evident on the face of the record. There is no genuine dispute about any material fact. Mr. Ortega submitted detailed plans for a 9-foot-tall shed. 3 HOA board members, including the president Patricia Henderson, approved those plans in writing. Mr. Ortega built the shed to those exact specifications. The HOA guidelines allow structures up to 10 feet tall. 8 months later, Ms. Henderson threatened to sue my client for $20,000, claiming the shed violated guidelines. When we responded with legal representation, they actually filed the lawsuit, increasing their demand to $25,000. They have provided zero evidence that the shed violates any rule because it doesn't. This lawsuit exists solely to harass Mr. Ortega, and we believe it's connected to his refusal to hire the HOA president's son's construction company. That is abuse of process, and we ask this court to grant summary judgment on both their claims against Mr. Ortega, which are meritless, and on our counterclaims. Judge Brennan nodded. "Mr. Paulson, I'll hear from you." Richard Paulson stood. He looked uncomfortable. "Your Honor, the HOA maintains that the approval was given in error. The committee members didn't properly measure or evaluate the shed's impact on the community. When the error was discovered, the HOA had a duty to enforce its guidelines." "When was this error discovered?" Judge Brennan asked. "In September of last year, Your Honor. 8 months after approval. And what guideline does the shed violate?" Paulson hesitated. "The overall aesthetic standards of the community, Your Honor." That's not a specific guideline, counselor. Is there a height restriction that this shed violates? The HOA believes the shed is taller than the approved plans indicated. You have any evidence of that? Any measurements taken by a licensed surveyor or engineer? We have visual observations from board members, Your Honor. Judge Brennan removed her glasses. So you filed a $25,000 lawsuit based on visual observations, despite having approved the shed in writing based on detailed plans that showed the exact height. And you're asking this court to find that's not abuse of process. Paulson looked miserable. Your Honor, the HOA believed it had a good faith basis for the lawsuit. Based on what, counselor? Show me one piece of evidence that Mr. Ortega violated any specific written guideline. Paulson shuffled through his papers. He couldn't find one because there wasn't one. Judge Brennan put her glasses back on. I'm going to grant summary judgment for the defendant and counterclaim plaintiff on all claims. The plaintiff HOA's lawsuit is dismissed with prejudice. Mr. Ortega did not violate any HOA guidelines. He had written approval for the shed and built it to specifications. The lawsuit against him was objectively baseless. Rachel squeezed my arm. This was it. Judge Brennan continued. On the counterclaims, I'm granting summary judgment for abuse of process. The use of litigation to harass a homeowner over an approved structure is precisely what the abuse of process tort is designed to prevent. I'm awarding damages in the amount of $15,000, plus all reasonable attorney fees to be submitted by declaration. I'm also granting the request for an injunction prohibiting the HOA from taking any further action regarding Mr. Ortega's shed. It stays. Period. I felt like I could breathe for the first time in months. Furthermore, Judge Brennan said, her voice taking on a harder edge, I'm sanctioning the plaintiff and their counsel. Mr. Paulson, this lawsuit should never have been filed. You had access to the same evidence we all have. You knew or should have known that your client had approved this shed, and that there was no valid basis for the claims. I'm imposing sanctions in the amount of $5,000 payable to Mr. Ortega. This is a warning to your client and to you that the courts will not tolerate the use of litigation as a weapon to harass homeowners. Paulson looked like he wanted to disappear. Yes, Your Honor. Anything else from either counsel? Rachel stood again. Your Honor, we would also ask the court to consider that there may be a pattern of harassment by this HOA president. We have declarations from other homeowners describing similar tactics. We're not asking for relief on their behalf today, but we want to make the court aware. Judge Brennan nodded slowly. Noted. If there are other victims, they should consult with counsel about their own potential claims. This order is entered today. I'll expect the attorney fees declaration within 30 days. We're adjourned. The gavel came down and it was over. Outside the courtroom, I shook Rachel's hand, then hugged her. Thank you. I don't know what I would have done without you. You would have been bulldozed, she said honestly. That's what these bullies count on. Most people can't afford to fight, so they give in. You stood up, and now you've got a precedent that will help other people in this neighborhood stand up too. The judge's written order came a week later. It was comprehensive and damning. Judge Brennan had written a detailed explanation of her findings, including specific sections about how the HOA had abused its authority, how Patricia Henderson had acted with malice, and how the lawsuit was objectively baseless from the beginning. The order explicitly stated that the HOA was prohibited from taking any action regarding my shed, from fining me, or from bringing any further legal action on this issue. Any violation of the order would be contempt of court. Rachel submitted our attorney fees declaration. Her fees totaled $18,000. The total judgment against the HOA and Patricia Henderson, personally, was $38,000 plus costs. I waited for the check. In Arizona, judgments have to be paid within a reasonable time or you can execute on assets. Rachel sent a demand letter informing the HOA and Patricia that payment was due within 30 days. 28 days later, I received a cashier's check for $38,542.19, including costs. It came with no note, no apology, nothing. Just the check. I deposited it immediately and wrote Rachel a check for her fees. Even after paying her, I was ahead financially. More importantly, my shed was safe and I had a court order protecting me. But things in the neighborhood got weird for a while. Patricia didn't resign. She stayed on as HOA president, and she avoided me like I had the plague. Anytime I was outside and she drove by, she would stare straight ahead, refusing to acknowledge my existence. Fine by me. Other neighbors started reaching out, though. Marcus told me that 2 other families were consulting with attorneys about their own issues with Patricia. The Johnsons, who had moved away, heard about my case and contacted Rachel about potentially suing for what had been done to them. In June, there was an emergency HOA meeting. I attended. The meeting room in the community center was packed, standing room only. Patricia sat at the front table with the other board members, looking pale and angry. A homeowner named Greg Martinez stood up during the open comment period. I move that we remove Patricia Henderson as president of this HOA. She cost us nearly $40,000 in a lawsuit that we lost because she decided to harass a neighbor over a shed that was properly approved. That's our money, our dues, wasted on her personal vendetta. There was applause. Patricia's face went red. That lawsuit was necessary to maintain community standards, she said, her voice shaking. The judge said it was abuse of process, another homeowner called out. We read the court order. You approved his shed, then sued him for building it. That's not maintaining standards. That's harassment. The vote was called. Patricia Henderson was removed as HOA president by a vote of 43-7. She stood up, grabbed her purse, and walked out without a word. I never saw her at another HOA meeting. The new president was Deanne Foster, the neighbor who had offered to be a character witness. Her first act was to apologize to me publicly on behalf of the HOA. Her second act was to commission a full audit of HOA finances, because some people were concerned about where money had been going during Patricia's tenure. That audit revealed some interesting things. Over the past 3 years, the HOA had paid Henderson and Sons Building nearly $90,000 for various projects around the community. Some of those projects had been bid out to other contractors with lower quotes, but the board under Patricia had always selected her son's company. Several projects that had been marked as completed had never actually been done. The fountain repair in the common area, for instance, had been paid for twice but never fixed. Deanne called me in July to let me know what they had found. Sean, this is bigger than we thought. We're contacting an attorney about potential fraud. Patricia was steering contracts to her son's company and possibly taking kickbacks. Some of the invoices look fake. Are you going to report it to the police? The attorney advised us to. We're meeting with them next week. I did not know what happened in that police meeting, but in August, Patricia Henderson was arrested. The charges were fraud, theft, and embezzlement. According to the news report in the local Phoenix paper, she had allegedly stolen over $60,000 from the HOA over 3 years through fake invoices and overcharges from her son's construction company. Derek Henderson was also arrested as a co-conspirator. The story made me feel vindicated and sad at the same time. Vindicated because it proved that my suspicions about Patricia's motives had been correct. She had targeted me because I had not used her son's company, and she had been running a scam the whole time. Sad because this was my neighborhood, my community, and the person who was supposed to be leading it had been robbing us all. I got a call from a reporter at the Phoenix Herald in September. She was doing a story about HOA abuse and had heard about my case. I agreed to an interview, though I kept it anonymous. The story ran in October, exactly 1 year after I had received that first threatening letter. The article detailed several cases of HOA overreach in Arizona, including mine, and quoted Rachel extensively about homeowner rights and the importance of fighting back against bullying tactics. The article mentioned that abuse of process claims were rare but effective when HOAs stepped over the line. Rachel told the reporter, "HOAs serve an important function in maintaining communities, but they're not above the law. When an HOA or its leaders use their authority to harass homeowners, extract money, or pursue personal vendettas, the courts will step in." Mr. Ortega's case should serve as a warning to HOA boards that frivolous lawsuits have consequences. Patricia's criminal case went to trial in January, 15 months after my ordeal began. I was subpoenaed to testify about my experience with the HOA lawsuit. The prosecutor, an assistant attorney general named Linda Torres, walked me through the timeline. I testified about the approved shed, the threatening letter, the lawsuit, and what I had learned about Patricia's financial schemes. "Mr. Ortega, why do you think you were targeted?" Torres asked. "I believe it was because I didn't hire her son's construction company. I had heard from neighbors that Patricia steered work to Henderson and Sons. When I built my shed myself, I think she saw it as defiance and retaliated." Patricia's defense attorney objected, but the judge allowed it as my personal belief based on evidence. The trial lasted a week. The evidence against Patricia and Derek was overwhelming. Financial records, fake invoices, testimony from other contractors who had been underbid but not selected, testimony from HOA board members who said Patricia had pressured them to approve her son's company. My case was just one small part of a much larger pattern of corruption. The jury found both Patricia and Derek Henderson guilty on multiple counts. Patricia was sentenced to 4 years in prison and ordered to pay restitution of over $100,000. Derek got 3 years and the same restitution order. Their construction company went bankrupt. As for me, life went back to normal. My shed still stands in my backyard, a 9-foot-tall monument to standing up for yourself. I kept every document from the case in a file folder, just in case, but I never needed them again. The HOA under Diane's leadership became a completely different organization. They focused on actual community improvement instead of petty enforcement. They repainted the community signs, actually fixed the fountain, organized neighborhood events, and treated homeowners like valued members instead of subjects. Dues went down because we weren't wasting money on legal fees and fraudulent contracts. Marcus and I became close friends through the whole ordeal. We still joke about it sometimes when we are having a beer on my patio, sitting next to the infamous shed. "Remember when Patricia said your shed was going to destroy property values?" he said one evening. "I do." Meanwhile, she was literally stealing from everyone. Kind of poetic that she went after you and you ended up being the one who exposed her whole operation. I had not set out to expose anything. I had just wanted to keep my shed and not be bullied. But sometimes standing up for yourself has ripple effects you cannot predict. The best part came 2 years after the original lawsuit, when I received a letter from the Arizona Attorney General's office. They were doing a statewide investigation into HOA fraud following several high-profile cases, including Patricia Henderson's. They wanted to know if I would be willing to serve on an advisory committee to help draft new regulations for HOA oversight. I agreed. That committee met quarterly for a year. We drafted recommendations for increased financial transparency, mandatory audits for HOAs over a certain size, clear procedures for homeowners to challenge fines or lawsuits, and penalties for board members who abuse their authority. Many of those recommendations were adopted into Arizona law in 2027. I never imagined that a fight over a shed would lead to changing state law, but that is how it happened. Sometimes the most important battles are the ones you did not choose, the ones that choose you. My experience taught me several things. First, document everything. Every email, every letter, every conversation if possible. Those documents saved me. Second, do not be afraid to get legal help when you need it. Rachel's expertise made all the difference. I could not have navigated the legal system alone. Third, bullies rely on people being too scared or too tired to fight back. When you do fight back, they often fold because they never expected resistance. Fourth, and maybe most important, there are always people who will support you if you are in the right. Marcus, Deanne, and other neighbors had my back even when Patricia tried to turn everyone against me. Those relationships matter. I still live in Sunset Ridge. I still serve on the HOA board now, actually, as vice president. Deanne asked me to join 2 years ago, and I figured I owed it to the community to help make sure nothing like Patricia's reign ever happened again. We have good people running things now, people who understand that an HOA should serve homeowners, not rule over them. My shed is still there, still exactly 9 feet tall at its peak, still holding my tools and lawn equipment. Sometimes when I am getting something out of it, I think about that certified letter, that feeling of panic and anger when I first realized I was being sued for something I had not done wrong. I think about how close I came to just tearing the shed down to make the problem go away. I am glad I did not. I am glad I fought, not just for me, but for everyone else who has been pushed around by someone with a little bit of authority and no conscience. The court order I won is framed in my home office, right next to my desk. It is a reminder that the system works when you have the courage to use it and the evidence to back up your claims. The abuse of process claim was the key to everything. Rachel explained to me during one of our last meetings how important that legal doctrine is. Abuse of process exists because the legal system is powerful, she had said. Filing a lawsuit can ruin someone's life, cost them thousands of dollars, cause incredible stress. If people can use that power just to harass others, the whole system breaks down. That's why courts take abuse of process seriously. Your case was clear-cut. They had no legal basis for the lawsuit, they knew it, and they filed anyway. The judge saw through it immediately. Winning summary judgment meant we did not have to go through a full trial. Judge Brennan ruled that the facts were so clearly in my favor that no jury trial was necessary. That saved months of time and thousands more in legal fees. It also sent a strong message. The judge was not just saying I would probably win. She was saying it was so obvious that I should win that there was no point in even having a trial. The sanctions against Patricia and her attorney were important too. $5,000 might not sound like a lot compared to the overall judgment, but sanctions are rare. Judges do not like to sanction attorneys because lawyers are supposed to be able to advocate zealously for their clients. But when a lawsuit is so baseless that it crosses the line into frivolous, sanctions are appropriate. That $5,000 was Judge Brennan saying that this lawsuit should never have been filed, and that there would be consequences for wasting the court's time and my money. I used some of the judgment money to take my girlfriend, Zara Sullivan, on a vacation to San Diego. We had been dating for about a year when the HOA mess started, and she had been incredibly supportive through the whole thing. There were nights when I was so stressed I could barely sleep, and she would stay up with me, listening to me vent, helping me organize documents, telling me it would be okay. You know what the best part of winning was? I asked her one night as we sat on the beach in La Jolla, watching the sunset. The money, she guessed. No. The money was nice, but the best part was Judge Brennan looking at their attorney and asking him to show one piece of evidence that I had done anything wrong, and watching him shuffle papers because he couldn't. That moment when it was completely clear to everyone in the room that they had nothing, that I had been right all along, that felt better than any amount of money. Zara smiled. You're a nerd. Maybe, but I am a nerd who still has his shed. We got married a year later in 2027. The wedding was at a venue in Scottsdale, and we invited the whole neighborhood. Marcus was my best man. Deanne came with her husband. Even some of the HOA board members attended. It felt good to celebrate something happy after all the stress and conflict. Patricia Henderson was still in prison. I did not think about her much anymore. She had made her choices, and now she was living with the consequences. I hoped she learned something from it, but I doubted it. People like her rarely do. Derek Henderson got out of prison after serving 2 years of his 3-year sentence. I heard he moved to Nevada and started working construction for someone else's company. His own business was gone, his reputation destroyed. I did not feel sorry for him. He had knowingly participated in defrauding homeowners, including me. He had come to my house and tried to pressure me into hiring him, then supported his mother's retaliation when I refused. Actions have consequences. The ripple effects of my case continued for years. 2 other homeowners in Sunset Ridge filed their own lawsuits against Patricia and the old HOA board for harassment they had endured. Both cases settled quickly once the defendants saw what had happened in my case. The Johnsons, who had moved away, also filed a lawsuit and received a settlement that I heard was substantial. Rachel Kim became something of a specialist in HOA law after my case. She told me that she had received dozens of calls from homeowners dealing with similar situations. Not all of them resulted in lawsuits, but many did, and Rachel won most of them. She sent me a bottle of expensive scotch when she won her 10th HOA abuse case. The card said, "Thanks for being the first. You started something." I opened the scotch at a neighborhood barbecue. Marcus, Deanne, and several other neighbors who had lived through the Patricia Henderson era were there. We toasted to bad HOA presidents getting what they deserved and to good neighbors watching out for each other. "You know what's funny?" Marcus said, slightly drunk. "If Patricia had just left you alone, none of this would have happened. She would still be president, still running her little scam, still making everyone miserable. But she had to go after you over that shed, and it all came crashing down." He was right. Patricia's downfall started with her decision to target me. If she had just approved the shed and moved on, or even if she had sent me a polite letter asking me to make some minor change, I probably would have complied. But she came at me with threats and lawsuits, probably thinking I would fold immediately. Instead, I fought back, and the scrutiny that resulted from the lawsuit exposed all her other crimes. Sometimes I wonder what my life would have been like if I had not built that shed. If I had just kept using my garage for tools, never applied for approval, never dealt with the Architectural Review Committee, I probably would have avoided the whole mess. But I also would not have met Rachel, would not have learned about my rights as a homeowner, would not have helped change state law, and would not have played a part in cleaning up my neighborhood. The shed was worth it. 3 years after the original lawsuit, I was invited to speak at a conference for community association managers in Phoenix. They wanted someone who had been through an HOA dispute to share the homeowner's perspective. I was nervous about public speaking, but Rachel encouraged me to do it. "Your story matters," she said. "These managers need to hear what it feels like to be on the receiving end of HOA abuse. Most of them are good people trying to do the right thing, but some of them enable bullies like Patricia. Your experience can help them understand the stakes." The conference was at a hotel near the airport. There were about 200 people in the audience, mostly property managers and HOA board members. I told my story from start to finish. The threatening letter, the lawsuit, the counterclaim, the summary judgment, Patricia's arrest. I talked about the stress, the financial burden, the feeling of being ganged up on by people who were supposed to be my neighbors. "The thing that bothered me most," I said, "was not even the money or the legal fight. It was the feeling that I had no power. That Patricia and the board could make up any rule, accuse me of anything, and I would just have to take it. That's what abuse of power feels like. You feel helpless. And most people in that situation do give up because fighting is expensive and exhausting. I got lucky. I had enough money to hire a good attorney, and I had evidence that clearly proved my case. But a lot of people don't have that. They get steamrolled." The audience was quiet. After my talk, several managers came up to thank me. One woman said that she had been working with an HOA board that reminded her of Patricia, and my story gave her the courage to quit and find a different client. A man told me he was a board president who had been trying to get rid of a corrupt vice president, and my experience showed him that legal action was possible. The conference organizers asked me to come back the next year. I did, and the year after that. It became a regular thing. Speaking to those audiences felt like a way to honor what I had been through, to make sure it meant something beyond just my own vindication. Zara and I bought a bigger house in 2028. We stayed in Sunset Ridge because we liked the neighborhood and the community had really improved. Our new house had a bigger backyard, and yes, I built another shed. This time I made it 8 feet tall just to be safe, even though the guidelines allowed 10. No sense tempting fate. The new shed is blue, matching our house. It holds my tools, my lawn equipment, and now also Zara's gardening supplies. We have started growing vegetables, and she is surprisingly good at it. We have tomatoes, peppers, cucumbers, and herbs. The shed keeps everything organized. I submitted the plans to the Architectural Review Committee, of course. They approved it in 3 days. The new committee chair sent me an email saying, "Looks great, approved. Thanks for being thorough with your application." No drama, no threats, no lawsuits, just a functional HOA doing its job. That is how it should work. Looking back on the whole experience, I sometimes cannot believe it actually happened. That a simple shed could lead to lawsuits, criminal charges, and changes to state law seems absurd. But it did happen, and it happened because one person decided that her personal interests were more important than the rules, more important than fairness, more important than treating people with basic decency. Patricia Henderson taught me what abuse of power looks like. Judge Brennan taught me that the system can work when you fight back. Rachel Kim taught me the value of expert help. My neighbors taught me that community matters. And that shed, still standing in my old backyard, taught me that sometimes the smallest battles are worth fighting because they are really about something much bigger than they appear. I drive by my old house sometimes. The new owners seem nice. They have kids, and I see bikes and toys in the yard. The shed is still there, still painted to match the house, still exactly 9 feet tall. I wonder if they know the story, if the real estate agent told them about the lawsuit and the drama. Probably not. It is just a shed to them, a place to store stuff. But to me, it will always be more than that. It is a reminder that standing up for yourself matters, that bullies can be beaten, that the legal system, for all its flaws, can deliver justice, that ordinary people can make a difference when they refuse to be pushed around. The abuse of process victory was not just about winning money or proving a point. It was about sending a message that homeowners have rights, that HOAs have limits, and that crossing those limits has consequences. Judge Brennan's order was clear and unequivocal. The HOA had abused its power, and they paid for it. That message resonated far beyond my little neighborhood in Pleasant Valley, Arizona. Rachel told me she cited my case in at least a dozen other matters. Other attorneys around the state started using it as precedent. Law review articles mentioned it as an example of effective homeowner pushback against HOA overreach. It became part of the conversation about how to reform HOA governance in Arizona. None of that was intentional on my part. I just wanted to keep my shed and not be harassed. But sometimes when you stand up for yourself, you end up standing up for everyone in a similar situation. That is what happened here. 5 years after that first threatening letter, I got an email from a law student at Arizona State University. She was writing a paper about abuse of process claims in HOA disputes and wanted to interview me. We met for coffee in Temp, and she asked detailed questions about my experience, my decision to fight, and what advice I would give to others in similar situations. Fight if you have evidence, I told her. Document everything. Get a good lawyer. Do not let them intimidate you. The legal system can be expensive and slow, but it works if you are patient and you have truth on your side. She took notes furiously. Her paper, which she sent me a draft of later, was titled Homeowner Rights and HOA Abuse, Lessons from Ortega v. Sunset Ridge HOA. Seeing my name in an academic paper was surreal. I was just a guy who built a shed and refused to back down. Now I was a case study. The paper concluded that abuse of process claims were underutilized by homeowners facing frivolous HOA lawsuits. The student argued that more homeowners should be aware of this legal tool, and that courts should continue to take these claims seriously to deter HOA overreach. She cited my case as a model for how to successfully defend against baseless HOA litigation. I felt proud reading that. Not proud in an arrogant way, but proud that my fight had contributed something to the broader conversation about homeowner rights. Time passed. Life moved on. Zara and I talked about starting a family. Work kept me busy. The HOA continued to function well under Deanne's leadership, and eventually under new leadership when Deanne stepped down after serving 2 terms as president. The neighborhood thrived. Property values actually went up, ironically, after Patricia was removed and arrested. Turns out that having a corrupt HOA president is worse for property values than a 9-foot-tall shed. I still have the original threatening letter framed in my garage, next to the summary judgment order. Visitors sometimes ask about them, and I tell the story. It never gets old. People are always shocked that an HOA could be so petty and vindictive. I remind them that Patricia did not represent all HOAs, just the worst of what can happen when unchecked authority meets bad intentions. The shed saga, as Zara calls it, became a defining experience in my life. It taught me to stand up for myself, to trust the legal system when I have a strong case, and to never underestimate the value of good documentation. It also taught me that justice, while sometimes slow and expensive, is worth pursuing. Patricia Henderson got out of prison last year after serving 3.5 years of her 4-year sentence. I heard she moved to California to live with a relative. I hope she learned something from her time behind bars, but I am not holding my breath. Some people never change. Derek Henderson is apparently doing fine in Nevada, working construction and staying out of trouble as far as I know. He paid his part of the restitution in installments over several years. I never spoke to him again after the trial. As for me, I am doing great. Zara and I are expecting our first child this summer. We are converting one of the spare bedrooms into a nursery. I submitted plans to the HOA for the modifications we are making, even though they are all interior and technically do not require approval. Better safe than sorry. The new HOA board approved the plans in 2 days with a congratulatory note about the baby. That is how a functional HOA operates. Sometimes late at night when I cannot sleep, I think about what would have happened if I had not fought back. I would have torn down the shed, paid thousands of dollars to the HOA, and lived the rest of my time in Sunset Ridge feeling defeated and helpless. Patricia would have continued her schemes, stealing from every homeowner, and none of us would have been the wiser until even more damage was done by fighting. I saved myself and helped save the community. That is not hyperbole. The financial audit and subsequent investigation revealed that Patricia was on track to steal over $100,000 from the HOA over 5 years. My lawsuit and the scrutiny it brought stopped that, so yes, the shed was worth it. Every penny spent on legal fees, every stressful night, every anxious moment waiting for the judge's ruling. It was all worth it because standing up to bullies is always worth it, and because the outcome benefited not just me but everyone in the neighborhood. I hope my story encourages others to fight back when they are being wronged. Not every case will result in summary judgment. Not every HOA dispute involves criminal fraud, but the principle remains the same. If you have evidence, if you are in the right, and if you are willing to fight, the system can work for you. Abusive process is a powerful claim precisely because it protects against the misuse of the legal system itself. Courts do not like it when people file lawsuits for improper purposes. When you can prove that someone sued you not because they had a legitimate claim, but because they wanted to harass you or punish you or intimidate you, courts will act. That is what happened in my case. Patricia's lawsuit had no legal merit. She knew it, her attorney should have known it, and Judge Brennan certainly knew it. The summary judgment was decisive and complete. We won on everything. And that shed, that 9-foot-tall, properly approved, completely legal shed still stands. It outlasted Patricia's presidency, her freedom, and her reputation. It is a monument to the idea that sometimes you have to fight for what is right, even when the fight seems ridiculous. I built a shed. They sued me. I countersued for abusive process. I won. Patricia went to prison. The neighborhood improved. Justice was served. That is the story. That is my story, and I am proud of it.